Lords, over the luncheon adjournment, Miss Smythe and team have provided a copy of the Convention on Reduction of Statelessness, which the court asked for.
Very helpful, thank you.
Miss Smythe has received some further instructions that she might wish to present before the court. Might be sensible before I carry on. Thank you.
My Lord, yes, I spoke to Ms Knight over the break and we thought it might be helpful if I set out our position in relation to Article 8 before Ms Knight makes any further submissions. So the position is this. I've obviously made submissions on the law. It's fair to say that as things stand, there is an undetermined Article 8 claim in the Upper Tribunal. And therefore, there are two main alternatives. If the Secretary of State wins on the public law ground, we accept that there's an undetermined Article 8 claim in the Upper Tribunal which would need to be determined. We don't think this court needs to find there to be an error of law in relation to what the Upper Tribunal said about the Article 8 claim for that to be the case. The fact is, if one imagines it in terms of ordinary litigation, in a sense that can be regarded as having been stayed. So there was an Article 8 argument made in the Upper Tribunal, it wasn't determined, so it's still there.
Yes.
So that, in that sense, that's what happens if we win. If we lose on the public law ground, the Secretary of State would remake the decision whether or not to deprive, and if that's a negative decision, there would then be a fresh right of appeal. So that would leave an issue as to the rump of the Article 8 claim in the Upper Tribunal, but that wouldn't be a matter for this court. So those are the two alternatives in terms
Neither of them. Article 8 doesn't need to be
exactly. And I should just say that the Secretary of State's position, we've set this out in our skeleton, what the Upper Tribunal did in not considering Article 8, we say isn't an error of law, and Ms Knight disagrees with that. But we do say, and we've said in our skeleton, that it's good practice for the tribunal to decide it if it's raised, precisely because we would know what the tribunal had to say about the Article 8 claim for the purposes of this appeal. But again, ultimately, we accept how the tribunal deals with its own procedure as a matter for that tribunal and not this court. So where that leaves us, effectively, is that we accept that Ms Knight doesn't need to show it was an error of law not to consider the Article 8 claim to get the Upper Tribunal to consider the Article 8 claim, because as I've just analysed it, I'm sorry, it's still there. Does that sort of help cut through the issues?
I think it does, and it gives you what you need, doesn't it, Ms Knight?
Well, it doesn't change our position. It gives us what we need from my individual client. It doesn't change our position that this court should try and resolve, if it can, the Chimi-Chicheri dichotomy, because one of the issues that still arises post Chimi or in Chimi is that the approach it invites the tribunal to determine when there is an Article 8 appeal, which is to disregard the discretion.
Well, just this pause. You accept that you don't need, from your client's point of view, for us to determine this point, but you invite us for the greater good. I don't mean that rudely. It may well be a sensible thing to do, to say whether, as a matter of law, he erred in not proceeding to deal with the Article 8 point, which you say is because of following Chimi rather than Chicheri.
Yes.
Now, so far, it's just had that heading, Chimi-Chicheri point. We haven't seen what you say Chimi says that is wrong. If you want to make that point, you may. Do you want to make it now as a self-contained point before we move on? There might be something to be said for doing that.
I was going to go back to...
Or you might deal with this at the end, okay?
If I may, I might just go back to... I'm happy to do it either way. I was just going to go back to the policy where I was and then deal with the Chimi-Chicheri.
No, you deal with this as seems best for you. It may be in the end we don't accept there's anything in it, but we'll let you run it. So
thank you. I will, my lord. We set it out in full in the skeleton, so that
don't say no more about it now. Either deal with it or now.
Yes, we're not. Let's move back to where we were. So that this is just going back to the policy. And this is how we put it in our skeleton argument in before this court, paragraph 22, and how we put it before the first tier and the upper tribunal. So there are just the relevant parts of the guidance. I just took the 153 supplementary hearing bundle, tabs 13. The general power is under 55.3. 55.4 deals with the definitions, and I think it answers the question about operative concealment at 55.4.2 and fraud 55.4.3. One passage to bring to the court's attention is 55.5.1, no specific time limit within which the procedures must be initiated, and bearing in mind the contrast with the previous position, which was the 14-year point, if I can put it in those terms. But important for these purposes, at 55.7, which is at page 156, 55.7.1, if the relevant facts had been known at the time the application for citizenship was considered, it would have affected the decision to grant, and it includes 55.7.2, 3 bullet points. The third one, false details given in relation to an immigration or asylum application, which led that status to being given to a person who would not otherwise be qualified. And you just observe Mr. Blundell's submissions on that, which is that some false representations, false details in an asylum claim wouldn't necessarily count for these purposes. And then 55.7.3 is a direct bearing point, and it gave the example of the concession at 55.7.4, where someone acquired ILR under a concession. But in relation to minors, and the two passages which we say are material here in the application of the policy, 55.7.5. In general, the Secretary of State will not deprive of British citizenship in the following circumstances. And the second and third bullet point, the third bullet point, if the person was a minor on the date at which they acquired ILR, indefinitely to remain, and the false representations or concealment or fraud arose at that stage, and the leave to remain led to the subsequent acquisition of citizenship, we will not deprive. So just answers my Lord Justice Dingemans' point, I think, which was that if the person was a minor at the time they acquired leave, even if subsequently there are representations, applications for naturalisation, subsequently they won't ordinarily deprive, unless, and there's a caveat of course there, where it is in the public interest despite these factors. And then 55.7.6, length of residence alone will not normally be a reason to deprive, alone. A reason not to deprive, sorry. So that was the 14-year policy, which previously said if you've been resident for 14 years, then it wouldn't be the case. But this important part in the complicity test, and this is why I was just at pains to try to determine whether that was condition precedent or discretion, and I think the court was proceeding on the basis that it's discretion, which is that this is the point we put, the Secretary of State doesn't treat a person who was a child as complicit in the following circumstances. If a person was a child at the time the fraud or material, fraud, false representation or concealment was perpetrated, they should assume they were not complicit, any exception by the parent or guardian, sorry, it's not that part. The next passage, 55.7.8.2, this includes individuals who are granted discretionary leave until their 18th birthday, having entered the UK as a sole minor who cannot be returned because of a lack of reception arrangements. Such a minor may be granted ILR after they reach the age of 18 without the need to succeed under Refugee Convention or make a further application, but the fraud was perpetuated when the
perpetrated,
but when the individual was a minor. And this is the passage that we rely on, 55.7.8.3. However, where a minor on reaching the age of 18 does not acquire ILR or other leave automatically and submits an application for asylum or other form of leave which maintains a fraud for false representation or concealment, which they adopted whilst a minor, they should be treated as complicit. And it's the correct facts in this case, and they're not in dispute, is that for these purposes, the respondent did not, after reaching the age of 18, do anything. He failed to retract his previous asylum claim or failed to tell his social worker the true position. But this, we submit on a proper reading of this is the way the case is put to the First-tier Tribunal and the Upper Tribunal, which is why we say that they reached the considerations they did on because the exercise of discretion was the Secretary of State, although she adopted the previous part, 55.7.5 third bullet point, she didn't read it across with her position in the policy, which requires an active step.
Can I understand that point, but can I just ask how you deal with the application on the 11th of May 2004, which was when, as I understand it, he was 23, and so therefore not a minor, and where he said he was Kosovan and said he was a good character.
And I'm absolutely confident I'm not misrepresenting the policy, but Ms. Smythe will tell me if I'm wrong, that the Secretary of State's position is that if you get in under this limb that you were a minor when you got your ILR, or that you didn't take any active steps and you acquired it after 18, that's ordinarily it, even if further applications are made, because all of those,
whatever their position,
I mean, of course,
it's for us to interpret the policy. And at the moment, can you help us with a reading that would support what you say their policy, informal policy is?
So effectively the reading is the Secretary of State's application of the policy in all of the cases I've been involved with for people who were minors. And not to say that, and I think the better position.
Well, my lord has asked you to help us on the wording, not
yes,
to tell us what your experience is.
Apologies, but the construction of the case, the construction of the policy is how the deprivation process is to be construed, and under 55.7, which is all this is under a heading, goes to material to the acquisition of citizenship. And so the Secretary of State is looking at the question of whether the fraud was material. And when
I'm not sure that's right. I mean, the paragraphing here is very odd. But I think, as I understand it, although it's all part of 55.7, it is actually a separate subject matter, complicit.
Well, yes, if we get 55.7 material and 55.7.5, so under the heading material to the acquisition, in general, the Secretary of State will not deprive British citizenship in the following circumstances. And it deals with the bullet point 3 about a minor, where there's a fraud which arose at that stage and leave to remain led to the subsequent grant of citizenship. Now,
what does led to mean? What if they make or repeat the original fraud, rather than simply relying on the fraud that happened first time round?
Well, my lord, my response, and this, because Miss Smythe has taken you to the process, and I think you've been taken to the process in some of the other cases, it is inevitable that in making an application for naturalisation, that one, absent, a coming clean at that point, in which case you wouldn't be in these circumstances, that those false details or fraudulent details would be repeated in the application and the grant in those terms.
Is that right?
That's what the process...
It depends what the misrepresentation is. If it's about your name and your date of birth, no doubt those details of that kind, they will be common to both applications. But it wouldn't be so with all false representations, would it?
I mean, that's so. When we look at, if you read, if my lord goes back to 55.7.2 and the 3 bullet points, this is this is the wording. The third bullet point is false details being given in an immigration or asylum application, which led to that status being given, who would not otherwise have qualified, and so affected a person's ability to meet the residence and/or good character requirements for naturalisation or registration. So that's in my submission, the sequential link between that provision and then the determination that a minor would not nor ordinarily be deprived. So it's because, as pointed out by all counsel, deprivation isn't simply would you have qualified at the time or you weren't of good character. It actually, because it's a process that has to be invoked, there's a policy that just this policy informs the discretion, and some people are out with some people like minors, for example, who under bullet point 3, 55.7.5, the Secretary of State has a policy position in general terms that she won't deprive, and that's her policy position. And reading that then with the question of complicity, so for example, at 55.7.1, if a person was a child at the time of the fraud, and that was it should assume that they weren't complicit in any deception by the parent. Well, I think one would accept that's probably quite fair enough. What goes on then, which is where a minor reaches the age of 18 and doesn't automatically acquire, and submits an application for asylum or other form of leave which maintains the fraud, which they adopted whilst a minor, they should be treated as complicit. And this is the point I was foreshadowing in my sort of opening summary. And we say that the reading of the policy, and this is how it was put to the First-tier Tribunal.
That's how it was put to the point, but just tell us what you say it is.
Yes, the point of this is that this reading of the policy is that minors who don't actively submit a further application for asylum in order to acquire their ILR or other leave, and that's the situation here, because the respondent got ILR refugee status without doing anything further. He didn't withdraw his asylum claim, he didn't do anything further 71 days after he became an adult whilst he was in the care of the local authority. That's where we say that he shouldn't be treated as complicit, and where the Secretary of State says he was complicit in her decision letter, that's why we say she wasn't properly applying her policy. And it was on that basis the case was put to the FTT and the Upper Tribunal as part of the failure to properly apply the policy. And that's why, in short, that's how we have the skeleton arguments before the FTT and the Upper Tribunal. If the court wants to see that, we can provide those. But that was one of the grounds on which the case was allowed or was put to both tribunals. That a rational construction of that is that he didn't fall to be treated as complicit.
Well, I mean, again, just on the 57.8.3, he's reached 18.
Yes.
And he submits an application. It's not for asylum or other form of leave.
No, he'd already submitted his application.
But yes, it's not the things. But he's applied to naturalise as a British citizen.
Yes, but I accept that. But if you read it together, my lord, in my submission with back to 55.7.2 bullet point 3, you give false details in relation to an asylum immigration application, which led to the status being given, i.e. refugee status or whatever indefinite leave in this case. And you have to have the qualifying condition for naturalisation is that you have to have indefinite leave to remain, and you have to have had it for more than 5 years. That's for these purposes, the qualifying condition. And so that's where the Secretary of State says, I will overlook that. So in material to the circumstances is the material to the acquisition. That's bullet point 3. 55.7.5 won't normally deprive. Bullet point 3, if you were a minor at the date you acquired ILR, which led and that the leave led to the subsequent grant of citizenship.
And what about? I understand that bit of the construction on 8.3. Thank you. And how do you deal with 8.5?
And that is all adults should be legally held for their own citizenship application,
Responsible for
even
that.
where it's part of a family application. That is and complicity should be assumed unless sufficient evidence of mitigation is provided. I wrote in my submission, those are discrete because they're dealing with a person who was a minor who becomes an adult, but
Which
who
your
doesn't take an
client
active
was.
step. But I accept 55.7.875 is there. How one reads that with, there's an express provision in 8.3 that a minor who becomes an adult doesn't submit an application.
But isn't that dealing with a pre-existing application which has given them the status that enables them to apply for naturalisation?
Yeah, and that's precisely.
What about the situation though when you apply for naturalisation and tell a lie in that?
So, can I just answer my lord's first question, which is, or observation, which is this respondent was precisely in the situation. He applied for asylum when he was 17, and it was granted when he was 18.
That's why I asked for the next question,
So
which is.
But the Secretary of State's position, which in my submission comes from the construction of 55.7.2 and 55.7.5 bullet point 3, is if you were a minor on the date which you acquired ILR that led to the grant of leave to remain, which led to the subsequent acquisition of citizenship, we will not deprive in general.
Yes, but isn't that on the assumption you don't continue the lie in the naturalisation application?
Well, in my submission, it's extremely unlikely because in order to apply for naturalisation, one has to present one's ILR, the grant of ILR. The precondition is to have indefinite leave to remain for 5 years, and it's in a certain name. And if this is either about name, age, nationality, or history.
I see all that, but isn't that only saying that if the only lie is about your immigration history,
Yes.
and that goes back to something that happened when you were a minor, that won't exclude you. But if you tell a fresh lie in the naturalisation application itself, none of this applies. Is that not how it would work? It'd be very odd if it wasn't how it worked.
Well, the history of the cases, for example, in the other examples of complicity, or person who's not complicit, for example, an individual who's granted discretionary leave to their 18th birthday, having entered as a minor but can't be returned. If they had given my understanding, and certainly as I say, I hesitate to say how it's been operating in practice, but been operating in practice for.
Well, I don't know how it's been
where
operating
there's
in
been false
practice. You can't
details
give
in
evidence about that. I don't know what it means.
But in relation to an asylum claim, my submission is that where those false details have been given in an asylum and immigration claim that's led to the grant of indefinite leave to remain, even where those are repeated, such that you wouldn't otherwise be, it would ordinarily be the case that they'd be determined as material for the acquisition. These are operate as exceptions to that general position.
Can I just ask you that, is just so that you can help and reply on the construction of the policy, isn't the policy making a principled distinction between someone like your client comes in 17, gets makes a false claim because he's misled by naughty interpreters and all the rest of it, gets his ILR, then qualifies if he comes clean and says, look, I'm sorry I came under false pretenses, it was all the interpreter's fault, etc. Now I'm making an application for citizenship. And then the Secretary of State's not holding that against him.
Well, my lord, the reason I say no is because this is a deprivation policy. So it assumes that there's been, the person in that scenario wouldn't have been granted ILR, wouldn't have been granted citizenship, because they come to the Secretary of State and say, these are all the things I've done.
Well, they might have been, but it wouldn't have been because of a fraud, because at the time of the grant of the citizenship, the fraud had been revealed,
yes.
and a truthful application
Yes,
for
and that's,
naturalisation had been made.
that is my understanding of the construction and application of the policy, because this is where the Secretary of State is, when she can sort of elides two questions. One is good character. Yes, we weren't of good character if the question, all the factors had been known. But the deprivation policy doesn't simply say we're going to deprive you had we known. It says we're going to deprive you in these circumstances, and these are the exceptions. And that's what we say is an operative exception, because, as my Lord Justice observes, at the time of the application for naturalisation, the whole point of the policy is that the fraud isn't known, and the question is later whether, and if so, on what grounds should we deprive, and who should we exclude from that. And one of the categories for exclusion is persons who made their claim and acquired ILR as a minor. And the intersection between 8.3 and 7.5, we say, in these very relatively unusual circumstances, because there was no active step, and that was the key.
So relatively unusual circumstances because
he came as a minor, but was granted as an adult, but he didn't take an active step into between to acquiring the ILR, and that's, we say, is the nub of our error of law or misapplication of the policy point that was put before the First Tier and the Upper Tier Tribunal.
Thank you.
Thank you, my Lord. I don't need to say anything further about. So that's how we say the policy was construed, and you find that we don't necessarily need to go there. And the First Tier Tribunal deals with that in more detail.
Well, hang on, but the First Tier Tribunal got it wrong. The Upper Tribunal
got
has
it wrong
held
on the
it
basis of
wrong.
condition precedent, but he does record.
No, but they got it wrong on the other point as well.
Yes, on the Article 8, but the First Tier Tribunal made those findings saying it wasn't, condition precedent wasn't met. It was overturned by the First Tier, but the submissions
By
made
the Upper Tribunal.
which then go into the question of discretion, which is why I was at pains when I opened to say, where does the policy fit in? Is it ordinary public law discretion points, or is it condition precedent? And when we were before the Upper Tribunal, the policy struck, that same argument was put, but in the context of whether the Secretary of State had properly considered the exercise of her discretion with reference to her own policy on that point, given his age and his status as a child in care, in particular at the relevant time of the grant of ILR. That was a significant point that was put. He was called to give evidence before the Upper Tribunal and gave evidence about his circumstances at the time of arrival, and
Sorry, just so I can see where we're going.
Yes.
We've heard your submissions about the policy.
actually, sorry, yes, I should just take you to two other parts of the policy, and then I can move on just move on. One other point on the policy, which was that at the bottom of 159, and this sort of goes into Miss Smythe's point, 55.7.11.6.
Hang on, 55.7.
7.11.6. It's the bottom of 159 and the pagination.
Thank you. Yeah.
Which says that the caseworker should consider the impact of deprivation on the individual's rights under the ECHR, and whether deprivation would interfere with family and private life, and if so, whether such action would nevertheless be proportionate. And in some cases, it might be appropriate to remove citizenship but allow the person to remain. In such cases, you consider granting leave in accordance with guidance on private family life. So, we say very clearly that the reasons why this is not just a question of, well, it's good practice to determine the Article 8 claim, is because the Secretary of State's inviting representation.
Sorry, I'm getting confused. I thought, are you still on the point about departure from the policy for people who tell the lie?
No,
Can we put that point to bed?
Right, yes, thank you.
Right, because I thought the point about Article 8 you said you were going to come to at the end in relation
Yes,
to
but as I was in the policy, I thought I'd just take
No,
the
I
court
think,
to it.
speaking for myself, I'd rather you dealt with it in a
I'm
more
happy to
structured.
come back to that, yeah. So that was how we put the question in relation to the part of the Secretary of State's decision making in relation to discretion was the points before the First Tier and the Upper Tribunal.
Okay, we've got the departure from policy,
Yeah.
55.7.
And
Anything else you need to say about that?
no, in relation to policy, no, or no, not in particular. And so we then come on to the tribunal's decision not to determine the. Actually, so before I come to Article 8, let me just come back to the tribunal's determination, because then we can just see how the matter was dealt with by him in response to Miss Smythe's position. So that it is right to say that point on the construction of the policy wasn't directly put in the representations. The fact that he was a minor when he came was put. The fact that he required ILR without any further application was also put. But
Wasn't linked to the policy. Yeah.
but it wasn't directly linked to the policy. However, it was in the First-tier Tribunal and in the Upper Tribunal. So that is on that basis that we say, although the court will see the tribunal's decision, that paragraph 11, you can see that the tribunal said that very little factual dispute, and they agreed the condition precedent been satisfied.
Sorry, it's just for my notes. Like I don't want to be oppressive, but I don't. What point are we on now?
So this is going to. So having looked at the question of the policy,
Yeah.
I'm now just responding to Miss Smythe's points about the errors of law by the Upper Tribunal.
Okay, that's very helpful.
So and then I'll come on to Article 8.
Yeah.
Just
No,
the errors.
that's very clear. I just needed to know. Okay, so you're on that. Yeah.
So I'm sorry, I moved to another bundle without saying where I was going. I'm in the core hearing bundle at tab 6, which is the Upper Tribunal's determination. And it's at page 38.
Yep.
Paragraph 11. Just miss my
Well, in that case, it's page 37. But anyway, yeah.
Oh, I see. Sorry, my bundle is 38. But anyway, paragraph 11. There's very little factual dispute as to the evidence thus far. They agreed the condition precedent is satisfied, and also look at the First-tier Tribunal's decisions and his immigration history. So those facts are not in dispute. The core issue is whether the Secretary of State has exercised his discretion at all, and if so, whether it be done lawfully. And so when the tribunal records the the submissions, and in paragraph 16 and 17, the first submission was.
Well, do we know what the submission? What the problem on this point is that he finds against the Secretary of State on the basis that he didn't address a large number of points which he should have addressed. Sorry, the fee, whichever it was at that time. And the burden of Ms. Smythe's submissions is she's taken us through the reasons and shown that she did appear to address every single point taken by the appellant in the representations. So, and that seems to be right, doesn't it? What's wrong about that?
Specifically, the Secretary of State didn't make any reference to the fact that the respondent was a child in care. Now, of its own, that is not.
Hang on 1 second. Okay. Child in care when?
He was a child in care at the time of the application, and he was a looked after child up until the age of 21.
No, you can't be a looked after child until after the age of 18. He may have been a former looked after child.
Apologies.
Well, sorry, these things are quite important.
Yes. But he was a child in care.
Well, he's bound to be in care, wasn't he? If he's under 18 without parents, he was certain. All these children are in care.
Well, but the Secretary of State simply treats him as a child and then says, when you became an adult, you should have on the day you turned 18. Effectively, that's her submission in the decision, or her decision in the letter. The day you turned 18, you should have disclosed your true circumstances to the Secretary of State. And when you got your ILR 71 days later or 70 days later, that period of time is the time in which you should have determined you should have disclosed your position. The submissions made to the Upper Tribunal I accept that the Upper Tribunal, I'll come to his actual reasoning on the 43 points, paragraph 43, which is of the decision letter. But it was also submitted in paragraph 17 of the Upper Tribunal judgment. This actor submitted that there was failure to take account of relevant considerations and a failure to provide any intelligible reasons. And the submissions made to the tribunal were about the policy structure. Now, we appreciate that this court hasn't got the first-tier tribunal, hasn't got the skeleton arguments. But those skeleton arguments demonstrate that, and that was the way in which the case was put to the Upper Tribunal, that he was an accepted minority when he sought asylum, granted as refugee in 1990, 71 days after he turned 18.
What are you doing now?
Sorry, this is just summarising. This is the summary of the position that was put to the Upper Tribunal. That's
What you are reading from Ms. Actor's skeleton argument, which we haven't got. That's not very satisfactory. If you want to give it to us, I suppose you can, but at no point has been made that the points made in the skeleton argument were not dealt with. Otherwise, we would have.
No, we're not saying that. Our point is at paragraph 17. Miss Akhtar submitted there'd been a failure to take into account relevant considerations. Yeah. She specified those in detail in the skeleton, or there was another counsel skeleton, in fact, and that's. I appreciate that the judge doesn't give any more detailed reasons, but he does. And his criticism of the decision is focused on this structural question. Miss Smythe accepts, as she did in her opening, that paragraph 43 is deficient because she says it should have said the previous and following considerations in the exercise of discretion. So, if we're on pure public law principles, we look at what was put to the Secretary of State and how she responded.
The Secretary of State did the Secretary of State specifically responded by referring to 55.7.8.5, paragraph 26 of the decision letter.
Yes, but what she didn't do. Sorry. Let me come back to the decision letter. She doesn't refer, we say, or accurately apply the provision that I just took court to.
But that's a completely different ground of appeal. I mean, that's not the basis on which the judge decided the case. The judge didn't decide the case on the basis that there was, he referred to the wrong bits of the policy or anything like that. It simply didn't address any of the points made. And that's the reasoning which the Secretary of State criticises.
Well, I mean, I see that. I can accept that there is. That is the way that the Upper Tribunal expressed their reasoning, and we know from Miss Smythe's submissions in respect to paragraph 43 that she says she's acknowledged that it's defective, that it should have said the following and the previous, and then
yes. But is that fatal if in substance they had addressed all the points? Isn't that just an error of wording?
In the Upper Tribunal had concluded that the Secretary of State hadn't taken account of all the material factors in the decision letter with reference to the reasoning, and in particular the point about if the condition precedents met, where does these discretionary factors fit in? And I appreciate that it's not written in the decision, in the Upper Tribunal decision, but it was the case put to him that the policy hadn't been correctly applied. That's what. The relevant considerations about a child who turns 18 without making further application distinguishes them from the ordinary deprivation procedures. Those were that was the way in which the case was put to the Upper Tribunal. I just thought it would be useful. The final, perhaps it's not the final point, but just responding. The Upper Tribunal, when refusing permission, addressed these grounds in some detail. That paragraph, sorry, if I can just take the report to tab 4 of the core hearing bundle. It's at
sorry, where are we going?
This is just the Upper Tribunal's refusal of permission. it's in
Where is it? Which
the core bundle.
core
So,
bundle? Yeah.
so we just, it's 2 tabs before the decision of the Upper Tribunal.
Which tab is that?
So it's tab 4.
Tab 4. Thank you. Yep.
And he addresses, sorry, I'll just take you to the relevant part. At paragraph 7, he starts his consideration there. He addresses in terms the grounds put. He says that particularly at paragraph 10, the tribunal was not. Sorry, I have to apologise for that. Just taking us to the. Paragraph 9 says the Upper Tribunal was unarguably entitled to conclude the question of discretion was only expressed in paragraph 43 of the Secretary of State's decision, and it goes on to look at the question in relation to Article 8. He says at paragraph 15 the first mention of discretion was only made and arguably entitled to focus on that passage when considering whether discretion can be exercised lawfully. No submission was made at the resumed hearing at 35, but that in and of itself constituted the appropriate exercise of discretion.
Sorry,
paragraph 15 of his.
If you're just reading it out, what's the point you're making?
So he considers this is the judge's response to the question, and his submission or his conclusion was that that there'd been a particular focus on paragraph 43, and the reference to following factors was not, as he says, factors which had already been set out and considered above. So, and he then says in response to the grounds that were put to him, suggested there's no logical reason to require the Secretary of State to repeat the considerations twice. It's not self-evident they've been taken into account at all. And he goes on to express himself there. So that's the appellant's the respondent's response to the Secretary of State's grounds of appeal, which are it's been accepted that the decision letter is defective in terms. Those were Miss Smythe's words.
I think it was accepted that the language in paragraph 43 was deceptive in one particular respect. Yes, I don't think he accepts that the substance.
No, sorry.
No, fine. I just wanted to be clear about that. Yep.
My record of submission, Miss Smythe's submission, apologies, is that it was defective, and it didn't refer to those the matters that were following, or in fact, and or had gone previously. So that's as much as we say about that, and we do say that the way we put the case was in relation to the construction of the policy. So that then leaves us moving on, then, if I may, to the question to the Article 8 point, which so in short, I think we're agreed now that the tribunal didn't consider Article 8.
Yeah.
We're agreed now that it would have been good practice for them to do so.
Yeah.
We say that they should have done so because this is because it was considered by the Secretary of State, because it's referenced in the policy, because evidence was heard and called on it, and then no findings of fact were made. So that's just poor administration of an appeal if you have to do parts separately in a
Can I just ask this question? I mean, we know very often that judges presented with a personal injury trial might dismiss liability, and but even that then will go on to assess quantum, but they won't always. But if the judge has, in this case, said, right, Secretary of State has erred in public law by not exercising a discretion which she plainly had and had to exercise it, I quash the decision, send it back, and we all know that Article 8 issues are very mobile and change with time. You can well understand a judge saying, well, I'm not going to not going to waste my time. It only becomes important now that there has been an appeal, and on this hypothesis that it succeeds.
Yes, I mean, my lord, I understand there is a concept in the tribunal, and perhaps it's more confined to human rights appeals, about the one-stop process, and this court will have heard so much about that, in terms of an efficient use of court time and the tribunal's time. Having heard the evidence, So one of the questions Miss Smythe posed to me was whether, you know, if this should the articulate appeal go back now in any event, because where we are now, if there were going to be a new decision made on the deprivation, i.e. if we are successful in resisting the Secretary of State's appeal, then it would obviously make sense for any new decision to be made, including as to whether it was in accordance with the law because of the impact on Article 8. But so we would say that if there were going to be a new decision, that we should make a new decision on both on deprivation in the public law policy context, and then Article 8 reasonably foreseeable consequences. But if there wasn't going to be a new decision, then we say, well, the tribunal should certainly have dealt with it, because we wouldn't necessarily need to be here if there had been.
Yes, but his decision was that there would be a new decision.
The findings of fact. It's quite. I think in my submission, having gone to this is why we disagree with the approach in Chimi, and we invite the court to try to resolve it. I said I'd take the court to it, and it won't take very long to look at the decision from Chimi. We only really need to look at the head note, and it is set out in full in our skeleton argument. But
It's in the court, presumably.
it's joint call bundle 16.
Thank you.
So it's probably only necessary, I think, to look at the head note for these purposes. This is the decision of President Justice Dove, but perhaps the court could just read it for themselves, because it's fairly
The head note.
The head note.
Actually, it expresses a logical consequence. It doesn't actually say that if you have decided A or B, so the appeal falls to be allowed, it is wrong to go on and consider Article 8 issues. As my lord put it, that might be a matter of case management.
If it is a question of, and I'm conscious that we in the appeal before this court we agreed to this approach.
Before the Upper Tribunal.
Before the Upper Tribunal, I have to acknowledge that. Perhaps I can just take there's 2 points. The head note, paragraph 3 of the head note is something that we dispute in terms of what the tribunal may consider evidence which is not before the Secretary of State, which is understandable, but in doing so it may not revisit conclusions it reached in respect of questions 1A and B.
Because that was public law and only on the material before the Secretary of State, so to avoid cross-contamination, I suspect.
Well, I can see that stated in paragraph 75, but I've been looking for the reasoning which produces that subparagraph 3 in the head note.
Yes,
Can you?
I think it's paragraph 73. It's the passage. It doesn't. What it says is a tribunal which has detected no public law error in the Secretary of State's decision will not revisit that decision in the context of its human rights analysis. I don't know if that's the passage that Miss Knight has in mind.
You might say, well, of course it won't.
Exactly.
But so what?
Yes, I think that's our
So
construction.
what I'm looking for.
Yes, exactly.
I mean in this judgment at paragraph 85, the court moves on to look at the question of Article 8 and the principles which were we moved on to consider having rejected the public law question. We move on to consider whether rights under ECHR are engaged in this case. There's no dispute between the parties that's engaged, and assessment needs to be made in accordance.
Well, don't just read it out. What's the point?
So the point of that, so it appears here that the court is accepting that you only move on to the Article 8 question in circumstances where, that was my reading of the case, in circumstances where the public law grounds have been rejected. Looking back to paragraph 73, I can see perhaps there's more of a nuance in respect of that question, but we still, my submission still is that it is an error that if the tribunal, and perhaps this is the question, if the tribunal felt it was bound by, notwithstanding the concessions like made, but bound to adopt the two-stage approach, which is do public law first. If it succeeds, then that goes back, and then you come back for the Article 8 if necessary. That in light of in the circumstances where we've been looking for, and this court's been looking for 3 days at the ambit of the right of appeal and how it is effectively disposed of, and whether on public law grounds or fact finding and now Article 8, we would say that the proper approach is for the court to make findings fact on all relevant matters, and so that when it does go back to if it does go back to the Secretary of State on the policy ground, those findings they can inform the proper application of whatever consideration the Secretary of State needs to take, and that, I think, in my submission, is consistent with the U3 type approach. The court can make findings of fact as long as they don't undermine the overall conclusion in relation to the weight to be given to the Secretary of State's position on the importance of maintaining immigration control or integrity of the nationality system or the institutional competence question. So that's why we say, in a very small nutshell, why the tribunal should make findings of fact on all matters. And of course, the position has, because the Secretary of State's position has shifted on fact finding in relation to the determination of matters in issue of fact in terms of fraud and condition precedents. So we now revisit our position and say, well, we always said that there needed to be fact finding, but the reason that there needs to be fact finding in the Article 8 case is reinforced by the Secretary of State's new position that in the appeal, the tribunal should be invited to find facts on points of dispute. So it would be quite strange in a case where there's a dispute of fact on fraud, where you make findings on that, then it goes back to the Secretary of State to look at her public law position and you don't make any Article 8 findings. And if it had been common ground before the Upper Tribunal or the first tier that there should be fact finding on everything, there could be fact finding rather on the 40A question in relation to the fraud, then it would make sense to have a finding of fact on all matters that are relevant both to the exercise of discretion and or Article 8, so that if it needed to go back, the Secretary of State would have a clear factual basis that's consistent with U3, and if it didn't need to go back, then you just have a determination on Article 8. But either way, you don't split it off into two different strands, if you like.
Right. Well, let's see what you're saying on that.
So I think that's. I just wanted to go back to So my reading of the Secretary of State's policy, Secretary of State's skeleton, is that it's good practice, but not a requirement. Paragraph 50 for skeleton, and the tribunal doesn't err in law if it doesn't do so. And I think that, and she then goes on to talk about, submit at paragraph 51 that the three domestic questions are the question that we looked at, the Chowdhury three points, and then for the Article 8 to be decided, and that she submits is what the tribunal decided in Chimi. So, in my submission, that isn't, in fact, what, if Chimi says that you only, that's not a sort of straitjacket. I think the interpretation of the tribunal was that Chimi was a straitjacket, procedural and fact-finding straitjacket, and that, of course, was informed by the position the Secretary of State had on fact-finding until a couple of weeks ago. In my submission, that's quite clearly what informed the tribunal's approach. So for those reasons, we say that, further reasons to say that the tribunal should have determined the Article 8 and shouldn't have been constrained by it. I mean, I appreciate we agreed it, that's why we put the
No, but you made your position clear on that.
and the final, so I don't know if I need, in light of Miss Smythe's position that we should have an Article 8 determination, I don't think I need to address the court on this runoff, arbitrary, and so on, because the authority of this court in Aziz and Lachi and so on is that the court has to look, the tribunal, the FTT determination of Article 8 is looking at the reasonably foreseeable consequences of deprivation. There are distinct, the position in Begum was in relation to somebody who was outside the UK. That Secretary of State draws a distinction between those types of cases in her own published documents, and quite this, now that that's been agreed that there needs to be a determination, and we say that there's nothing that can be said by the Secretary of State to suggest that's not a material, that appeal couldn't be successful. We've got evidence to be determined by the tribunal, some of which was heard and not, but there was no determination on it. So for those reasons, we say that unless the court wants to hear me on Article 8, I don't need to address the court.
We need. No. Thank you very much, Ms. Knight.
Thank you, my lord. 3 sections, and I'll take this as quickly as I can. First, to deal with the public law argument. Second, to deal very briefly with the Chimi situation. And then third, just to mop up answering some questions that were raised this morning. So starting first with the public law arguments and the defence of my appeal, I make 4 points. So the first is this, that it's become clear that my appeal is being defended on the basis not that the Upper Tribunal was right for the reasons it gave, but that it should have decided the Secretary of State's decision was unlawful as a matter of public law because she failed to apply her own policy. That is a respondent's notice point. I'll deal with it, but there isn't a respondent's notice.
No, I understand that.
Second, however the argument is put, it's a bad point.
But hang on 1 second.
Yes, sorry.
Yes.
So however the public law case is put, it's a bad case. So could I then ask the court to turn back to tab 15 of the supplementary bundle, which is the guidance? And starting on page 156.
I think we were told there was no cover page for this.
Yes, that's right. I think that became clear in Chowdhury. And those
sometimes it's described as guidance and sometimes a policy. Not much may turn on it, but do we know what it is actually called?
I would describe it as guidance to decision makers. But
this must be chapter 55 of something.
Yes, it's.
What is the something of which it is for chapter 55?
Can I turn my back for a moment?
Yes.
It's the nationality instructions, so they were all available on the intranet. Although this,
Whether or not they had a physical front page, they must have had an overall title. They're called the nationality instructions.
So I'll double check, but a lot of it was taken away, and chapter 55 was one of the last ones to.
yes. So, and I'm being told that we'll check that the formal title is nationality instructions, but by the end of it, that there weren't 54 chapters before this. There were only isolated bits of the nationality instructions left. They've gone now.
I see. So this is okay. This is how there was once something called the Nationality Instructions, which went up to chapter 55 and maybe more. And over the years, they've been replaced by
Yes.
ad hoc policies, guidances, but a few bits remain, and this is one that remains.
It doesn't remain anymore, but it did at the time of this
This
decision.
one remained at the relevant time.
Yes.
Yes, I
Yes,
see.
but it's
And was, we think, called the Nationality, wasn't called instructions to caseworkers or something?
we're
Well, you don't know.
yes,
Well,
I'll add that to my list
nothing
of
turns on
questions,
it, but
the no.
we have to write a judgment, and one wants to know what to call
Agreed.
it in the judgment.
Yes, agreed. Now, so on to page 156, my Lord Justice Underhill is quite right that something has gone wrong with the headings because, as your Lordship rightly observed, sections which deal with mitigating factors, for example, in 55.7.11 and 55.7.10, are obviously not about the question of whether or not fraud's material to the acquisition of citizenship. So we would say that 55.7.1 to 0.6 stand on their own, and then the other sections are separate, just to be clear.
So what stands on it then?
Sorry, my lord.
Which one stand on its own?
So, for example, deliberate
Yeah.
is obviously about the Secretary of State's position, and rightly so, that if it's innocent, then there isn't fraud or misrepresentation.
In fact, what you said was that 55.7.1 to 6
Yes.
stood on their own and were governed by the heading material
But-
to the acquisition of
But I-
citizenship. Not even sure that's true about
No, I think-
55.7.6.
Yes, your Lordship's quite right, because that's in general, the Secretary of State will not deprive in the following circumstances. So I went too far. It stopped. Material to the acquisition of citizenship stopped at 55.7.4. Before I go any further, I have good news. The name of the document is British Nationality Act 1981, Case Working Instructions.
Thank you.
Chapter 55. Thank you, I'm very grateful to those behind me. So, turning then to 55.7.5, the Secretary of State will not deprive of British citizenship in the following circumstances. The third bullet, if the person was a minor on the date at which they acquired ILR, and the false representation, concealment or material fact or fraud arose at that stage, and the leave to remain led to the subsequent acquisition of citizenship, we will not deprive of citizenship. Well, in this case, he did not acquire the leave when he was a minor, and that's why the Secretary of State makes the point about you were an adult, so you should have corrected the position. So he's not caught by that bullet. And in any event, that doesn't deal with the character question. And the Secretary
Hang on one second. Yes, I wrote it down. He acquired ILR only until 71 days later.
Yes, so the
this
Secretary of
is
State
fine.
says you should have corrected the record. The other important point to make is that the Secretary of State does not have a discretion to disapply the good character requirement when she is deciding citizenship applications. So I would submit by this policy, she can't in effect do the same. So good
Well, is that because the character requirement is
it's a requirement of
it's a statutory
primary
requirement? And there's been some case, perhaps you were in them. I was certainly in a case about that sad Windrush case when that question arose.
I haven't
No,
done a
but
case
I remember
for a
that very
while,
point
but
came up that,
yes.
that it's a statutory requirement.
It's a statutory requirement. So the Secretary of State couldn't, by this guidance, effectively say, well, I'm not going to worry about the good character requirement when I'm depriving you of citizenship, because it clearly bites at the time. So that isn't addressing that bullet. And then, of course, as Miss Knight fairly said, however, where it's in the public interest to deprive, despite the presence of these factors, they will not prevent deprivation. And that, assuming that in this case he had acquired ILR when he was a minor, you might say, but it is in the public interest because thereafter you lied and got a Home Office travel document falsely, and you also lied in your naturalisation application. So even the bullet is not absolute where it applies.
Right. So you say for all those reasons, but primarily simply on its literal words.
On its
the first
literal
bullet
words.
doesn't apply. Okay.
Yes. And then we move on to the complicit section. Now, complicit, obviously, primarily is targeted at being complicit in deception which has been committed by somebody else.
It's not a word
That's-
that appears in the statute or the
No.
regs.
So this is about mitigation. This is clearly about mitigation. It's not about the conditions in section 43. So the first bullet is purely about what one would normally understand as being complicit. And then 55.7.2, the example is as follows, and it's necessary to take it quite carefully in my submission. So somebody who won't be considered complicit is somebody who was granted discretionary leave until their 18th birthday, having entered the UK as a sole minor who can't be returned because of lack of reception arrangements. That isn't saying somebody who has come in and lied and got refugee status, for a start. It's quite a specific situation that it's covering. It's covering somebody who's been given DLR who can't be returned because of a practical obstacle.
But it does show that complicit can apply to an individual.
I don't understand your
No,
logic, but
you said complicit was directed
It
to
d-
someone,
yes.
a child, but here it talks about a sole minor.
Sole
so
minor, yes.
It does show that on a fair construction, it's covering
yes,
both.
And if this were a statute, this would really be a deeming provision.
yes, I completely accept that although complicit normally means deception by somebody else, the Secretary of State accepts that if somebody comes in as a sole minor.
And it's really, I mean, I'm no point criticising the draftsman. It's not enforced anymore anyway. It really doesn't belong here at all.
No,
It's a
It-
different sort
it
of
doesn't.
exception.
yes, one would love to get one's hands on it and do a bit of redrafting, but plenty of other work to be doing. But yes, my lord, that's right. So, and then the next bit of that says such a minor. So, in other words, somebody who was given DLR, and then it says this may be granted ILR after they reach the age of 18 without need to succeed under the Refugee Convention or make a further application. Well, that's not this case.
But hang on, but in fact, anyway, it doesn't make any grammatical sense, the sentence. So such a minor may be granted after ILR without need to succeed or make a further application. That makes it, but the fraud was perpetrated when the individual was a minor. How does that fit in?
I think basically that's saying if you got it under 18 and then because you couldn't be returned and you've told some sort of a lie, but then after the age of 18 you get some other leave and you didn't need to succeed under the Refugee Convention to get that leave, then you won't be treated as complicit. But it's certainly whatever it covers isn't this case.
And to be fair, I don't think Miss Knight suggested it was. It's 57.8.3.
The difficulty with 55.7.8.3 is that it says who will be treated as complicit. It doesn't say who won't. So it's not the case that if you're not caught by 55.7.8.3 that you're fine. All it's saying is positively, if you're in the category under 55.7.8.3, you will be treated as complicit. It doesn't mean that in any situation in which you acquire leave automatically, in circumstances where you're an adult by the time you get it, but you weren't an adult at the time you told the lie, that you're off the hook. That's not what it says. And indeed, that would be inconsistent with what the Secretary of State's, the guidance says on the third bullet on page 157, which is talking about what happens at the date of acquisition of ILR. So what Ms Nike is seeking to do is draw from an example given of somebody who will be treated as complicit as anybody who doesn't fall within that paragraph won't be treated as complicit. But that's the wrong approach. That's not what the policy says. And construing it as a whole, sensibly and fairly, it's not saying that. What 55.7.8.3 is saying is where somebody on reaching the age of 18 doesn't acquire ILR or other leave automatically and submits an application which maintains a fraud which they adopted whilst a minor, they should be treated as complicit. So if one looks at the situation of somebody who also maintains other frauds, they are in a similar category to that person because...
But the point I made to Ms. Knight. I mean, you will, of course, tell me if you will look this gift horse in the mouth if it's wrong. That is dealing particularly, but if that's the position for an application for asylum or other form of leave, it should be a fortiori for an application for asylum, for naturalisation, shouldn't it?
Yes, and similarly,
Yes.
even if not a fortiori, it should certainly be the same.
Equally, yes, perhaps that's better. Than
It should be the
might be
same.
different.
A Home Office travel document, for example. I mean, there has been another fraud. And recall, of course, that the Secretary of State's good character guidance says whenever there's a deliberate deception of the Home Office, then we won't be inclined to treat you as being of good character.
But the structure of this seems to be, it's difficult to generalise about something which is so piecemeal, but it's really dealing with situations other than where you lie in the application, lie directly in the application of naturalisation itself, but where your immigration history is tainted by a lie and you wouldn't have been able to apply for naturalisation because one of the conditions you are claiming is one you weren't actually entitled to, most obviously ILR or refugee status. It's not really addressing the question where you make an application in the naturalisation application. Now, is that a bad point? I know you shouldn't. It seems to me that's what this is aimed at. Well, that's not what this is aimed at.
What it's not doing is dealing with the question of character specifically, and it's giving guidance on some quite discrete situations. The examples given in the policy are not examples in this case where, and as I say in 55.7.8.2, it's very specific. That's a person who shouldn't be treated as complicit. Then there's an example of somebody given who should be treated as complicit, but that doesn't mean that if you've told a lie as a minor, you're off the hook. For the general position on telling a lie when you're a minor, see the third bullet on page 157.
Can I just put something on this policy for you to say whether you think it's right or wrong? In fact, I mean, the heading material to the acquisition of citizenship, which is the causation point. In fact, I mean, of course, these are dealing with different aspects of it. But what the Secretary of State is saying when in mitigation or not complicit or you are complicit is this will be material or it won't be material. So it is in some respects all related to the material to the acquisition of citizenship. So it's not, I mean, in defence of the draftsman, but also trying to make sense of the policy.
Yes, but in my submission, what the Secretary of State can't do is change what the statutory language says. And the causation question in the statutory language was the citizenship obtained by means of fraud, etc. So even if the Secretary of State thinks these other things go to the materiality question, in my submission, when it's talking about, and this was the point my Lord Justice Underhill made in argument, and I would submit that it's right, is that what happened when you were a minor goes to the discretion, but it can't go to the question of whether the statutory condition is satisfied, unless, for example, one were to read into the language that the fraud must have been when you're an adult, which one can't.
In some respects, it doesn't particularly matter whether it comes under 2 or 3, the material or discretion, because the point is that the Secretary of State would apply the policy and find someone not complicit if they are within the policy.
In some circumstances, exactly, and would then not exercise her discretion to deprive. So that's where it comes in, and the court, and I would also say 55.7.8.5 appears here. It does say all adults should be held legally responsible for their own citizenship applications, and then it's dealing with even where this is part of a family application.
Yeah, but that's the real, that fits into my analysis of what this is really aimed at. Of course, adults must be held legally responsible for their own citizenship applications. How could this not be? But the real point is, if it's a family application, and I don't know, you may have several adults, or may have a wife, for example, other way around, signing up to something prepared by the spouse. This is 57.8.5 is really directed at the case of that applicant. That's all it's about.
It is, but I would say it's not all that. It's not all that it's about, because it's making a discrete point that all adults should be held legally responsible for their own.
Right, yeah, sorry.
So,
Of course
so-
it is, and
yeah.
of course anyone, we'd all assume that was so anyway. But it's all about the concept of being complicit in something which, as a matter of fact, was somebody else's lie.
Yes.
Yeah.
Yes. But by the time, of course, he makes his citizenship application, he is an adult, and that's where we
No, I
come
see
back
that.
to the
Well,
Secretary of State's point about
yeah.
character, which of course is entirely separate from any deception which may or may not have led to you getting leave.
Yes, right.
Which it's right to say, and I think the example given in 55.7.4, in some circumstances, and this goes, I think, to my Lord Justice Dingemans' question, in some circumstances a lie in relation to getting ILR will not have materially, it won't have led to the grant of citizenship, and that's the example given in 55.7.4. So if and this is as true for adults as for children, if somebody lies and says, I've lied about my asylum claim, but actually they were entitled to ILR in any event, then that hasn't affected the grant of citizenship, subject to any character point that might be taken on the facts of that case, but each case obviously considered on its own merits. What one can't in any sense derive from this policy is, once something happens as a child, you're basically the Secretary of State won't exercise her discretion to deprive whenever you've committed fraud as a minor. It's simply not what it says.
You've told us that this policy is no longer in force. There's now a separate instruction.
Yes, there's deprivation guidance which is published online and it's publicly
Is
available.
the language? I'm just wondering. We've obviously got to decide it for the purpose of this case, but whether there's an advantage in our going to town on this language, when it's no longer the relevant
Yes.
language. I mean, has it all been rewritten, or has it just been repackaged in identical terms?
Can I turn my back for a moment?
A lot of it was rewritten.
A lot of it has been rewritten, we think.
Double check. It's
I hope it
So-
was rewritten with a way to removing some of these obscurities. Yes.
So, but essentially, as a headline, I rely on the third bullet, and I say he's simply not caught by. There's nothing in the complicit section which really helps this appellant specifically. The other point to make about the guidance is that, recall when we were looking at the decision letter and the Secretary of State says, is it reasonable and proportionate to deprive you? The court will see that 55.7.10.1 is essentially posing that question. Should the discretion to deprive be exercised? In other words, the caseworker should consider whether deprivation would be seen to be a balanced and reasonable step to take. That's not in the statute, so it goes to the Secretary of State's discretion. That's why the question's posed in the decision letter, and again shows that the Secretary of State was exercising a discretion. Similarly, mitigating factors is obviously going to discretion. And then again, we get, and perhaps this deals to some extent with my Lord Justice Underhill's question about, well, what's 55.7.8.5 doing? It's now independently set out at 55.7.11.2 that all adults are expected to take responsibility for the information they provided on acquisition of ILR and or citizenship. So that's really focusing on.
Well, it's a classic problem, I suspect. I don't know. But with all documents, so including these sorts of Home Office documents, that the same thing is said several times in several different places,
Yes.
but not always in exactly the same words.
And this is focusing on adults. An adult will be held responsible for lies told to get ILR, but they will also be responsible for lies told to get citizenship. And the appellant was an adult when he filled in his form. So that's the guidance. I said I had 4 points under
Yes,
this
yeah,
head.
that was all your second point.
Yeah, it was.
No, that's fair enough. It was,
The third point is very short. It's insofar as there's any doubt about the Secretary of State's guidance, it's addressed in the decision letter at paragraphs 26 and 27, which is in the, and precisely these sections of the guidance are considered. So core bundle, tab
10.
tab 10, paragraphs 26 and 25, I'm sorry, and 26. So paragraph 25 is what I was describing as the third bullet. So this is in general, the Secretary of State will not deprive in the following circumstances. So that is 55.7.5 that we looked at, and the Secretary of
Sorry,
State.
just again, just really for judgment, right? But what are these annexes? That is
That's an annex to the first-tier tribunal bundle. So the Secretary of State puts together a first-tier tribunal bundle, and it will have a number of annexes. And what happens is that bundle is prepared at the time of the decision letter. So the decision letter refers to the annexes, which are then before the first-tier tribunal in that form.
there wasn't a tribunal at this stage.
No, but it's all done at the time of the decision letter, and I will check, but I think the material.
It honestly, again, just doesn't matter. It's just if one's writing it, or just
Indeed, yes.
Well, it matters a little bit more for yesterday's case, where the annexes weren't given to the person at all, whereas here they're obviously supposed to be.
This is a different kind of annex.
It's all provided with the decision letter.
Precisely, yeah.
These annexes. So what the Secretary of State says about 55.7.5 is, yes, you were a minor when you made the fraudulent asylum claim, but you were an adult for over 2 years before you acquired ILR. So you had ample opportunity to set the record straight, and you didn't. And then deals expressly with complicity and 55.7.8.3. And it also refers to 55.7.8.5, which I submitted does make a general point about adults being responsible. So the Secretary of State says there, you didn't automatically acquire ILR on reaching 18 years. So in other words, the Secretary of State saying that's for the situation where somebody acquires ILR automatically on reaching 18 years, and whilst it's accepted that no new application was made, you were aware of your outstanding application. This contained false information. So what that's doing is distinguishing two situations. One, where a person gets ILR automatically because they are 18. And secondly, the situation where somebody happens to get ILR after they are 18, because that's just the way things have gone chronologically. Yes. So what the Secretary of State says is, you didn't automatically acquire ILR on reaching 18 years. In other words, that's what that is directed to. And whilst it's accepted that you didn't make a new application, you were aware of your outstanding application and this contained false information. In other words, we don't treat you as not complicit when you've allowed an asylum application to remain outstanding, knowing as an adult that it's fraudulent. That's not, says the Secretary of State, what our guidance is intended to cover. And I've shown the court that it doesn't say that situation is covered. So in other words, if you make a false asylum claim before the age of 18, it's not been determined by the time you reach 18. At the age of 18, you are legally responsible. You are responsible for saying to the Secretary of State, I'm an adult now, hold on a minute, that's a false claim.
Yeah.
And then the letter adds, yes, you were expected to correct the record, not maintain silence in the hope of being granted leave. So that's the difference with somebody automatically acquiring on their 18th birthday. It doesn't require anything to be done by them. Here, this was an asylum claim, and you don't automatically get it before you turn 18. And then, of course, the final point made there, no claim is made that you were not complicit in the deception practice when you applied to naturalise.
That's the point that I was putting to you.
Yes, exactly. So that's a discrete, and another thing. So there's one good reason you should have corrected it. And by the way, secondly, you've lied in your naturalisation application. So that then takes me to the final point here, and it's this, that yes, I accepted that the letter wasn't perfectly worded. My skeleton argument isn't perfectly worded, judgments aren't perfectly worded, but that doesn't make it defective in any meaningful sense. So just to be clear, that's all I'm saying. But clearly, given that it's not a contract and it's not a statute, it's entitled not to be perfectly worded. There's plenty of authority about that.
So it would have been better if the word also, the Secretary of State has also taken into account the following factors,
Yes.
in addition to the obviously discretionary matters we've already referred to.
Exactly, but if this were defective in public law terms for that reason alone, the courts would be flooded with claims. That's
I'm
not,
suggesting the Home Office doesn't always write perfect letters.
no, and this one has to say it's not perfect. It is a
No.
good letter.
Yeah.
So that's my answer on the public law section. On Chimmy, I can be very brief. And we certainly had read Chimmy as banning the Upper Tribunal from deciding Article 8 if it has allowed the claim on public law grounds. And I have nothing to add on the Chimmy point to what is in paragraph 50 of our skeleton. And my Lord Justice Dingemans quite rightly makes the point, and I made it a bit just in outline, which is one can't force a court to decide a particular point if it decides that it shouldn't decide that particular point, and the personal injury is a good example. One might have said in all sorts of cases, well, this court should have decided points because it went on appeal and then the Supreme Court didn't know what the court said, but that's not really the way the justice system works. So, but I've already made my points about that. We say that the tribunal didn't err in law, but there is an Article 8 claim which needs to be decided if I win on the public law point. So that's all I have to say on that. Unless I
mean,
can
you could
assist on that.
You could have a case, couldn't you? Sorry, don't want to prolong the argument on this, but where the claimant was going to win. The claimant had a very strong Article 8 case and was going to win on it. And there was also a public law defect. The effect of the public law defect is the decision has to be taken all over again by the Secretary of State. In those circumstances, if it was clear to the tribunal, it happens here to be the Upper Tribunal, but the fact-finding tribunal, that Article 8 requires them to be given leave or not to have their permission revoked, whatever, they really ought to go on and decide it on the basis of get rid of the whole case rather than go back to square one.
Yes, I think that's my good practice point, isn't it? Which is why it would
Well, that's
make
almost more than good practice.
Yes, it would make sense to decide it.
Well, I think it would probably be wrong, but it would require the judge to have decided, look, you're going to win on Article 8.
Yes.
And if you're going to win on Article 8, I'm not going to prolong the whole process by quashing the decision and not deciding the Article 8
Yes,
point.
because that's it. Yes, I think that must be right. And of course, I mean, it's a separate point. If the reason to decide
This wasn't said by the judge to be such a case.
no.
No, right.
No, and one would be surprised if the judge had considered it to be such a case for
might.
the reasons I've given. It's inherently
Yes,
weak,
quite.
but I say no more about that. It's also right to say that if, in terms of the sequencing of decision making, if somebody succeeds on a public law challenge, then it might be said that the decision isn't in accordance with the law, subject to that being a criterion for deprivation. It's not inconceivable, I suppose, that it could be arbitrary, but in any event, I think your lordship has in mind something different, which is the Article 8 analysis in terms of the consequences of deprivation. That would
Yes,
be
that is what I meant. Yes.
that would be a very rare case we would submit, and we
Well, it would in this context, yes.
yes, we included in our skeleton what the Upper Tribunal had to say about the public interest in deprivation. Effectively, where you've obtained something fraudulently and you're not entitled to it, that there's a
Well, it's
great-
basically the high sag, which we
It's the
agreed
high
with,
sag,
actually,
exactly.
despite the result in that.
Yes, that was an unusual case. So that's all I have to say about Article 8. That just takes me to the questions that were outstanding from this morning.
Yeah.
Question 1, when did the old policy on long residence go? It was the 20th of August 2014.
20th.
Of August 2014.
Is that coincidental with the coming into force of of the 2014 Act? No, it wouldn't. There's no logical reason why it should be.
No.
But I forget. Yeah. Okay. Thank you.
2, what prompted the inquiries with Albania? I can't answer that other than to say there was a referral from a different part of the Home Office to the deprivation team. What prompted that, I don't know.
Yeah.
finally, the question about Chahal, we can send a note on this to confirm, but our understanding is that was a concern about the old system for reviewing national security decisions in the immigration context, deportation, rather than deprivation specifically, and that's what led to the system with special advocates being introduced. But we don't understand that to have been about deprivation specifically and a concern with those 1982 rules. I'm comforted by the fact Miss Nike is nodding at me. So if needs be, we can confirm that. If the court would like chapter and verse on that, we're quite happy to send an email confirming it.
I mean, I think, Lord Hoffman sort of slightly glides over it in Raymond, but I think that's sufficient for our purposes. I wouldn't want to make you work even harder on all these cases.
And that's it, I think, in terms of the questions. So unless I can assist any further on our case, that's it. And I think Ms Knight has a right of reply.
But she has a right of reply on the respondent's
Yes.
notice
Only on the
points,
respondent's
which I think
notice.
really, well, let's hear what, is there anything you want to say, Ms Knight?
Well, there was just in response to the question, which was my Lord Justice Edis' point about the service of those annexes, and that isn't
Yes.
actually a respondent's notice point, but just in a sort of tidying up way. When we were issued with the notice of intention, those annexes were not served on. There's no suggestion that they were served on the applicant, on the respondent. So the letter is at supplementary bundle tab 11, page 103, and that's the 25th of May 2021. That's the notice that wasn't served.
Am I going? Oh, I see. Notice of intention. Yes,
Yes.
but we're looking at the notice of decision.
And in the notice of decision, there's no suggestion they were served either. Those annexes all refer to what goes into the Home Office bundle at the appeal, which I happen to have here, and they do all appear in the appeal bundle, but they didn't appear in
well,
the decision.
Odd, what an odd thing, but I mean,
Yes, but for the purpose, once we're thinking of this in public law terms, we give you notice, we tell you to make submissions on
no,
law
it couldn't
policies.
matter less. But I mean, anyone getting a letter with a reference saying Annex A, the first thing they'd say is, "Can I see this annex?" And so, well, you'll get it if you bring up FTT proceedings.
The bundle,
Am I misunderstanding?
the bundle is dated the 2nd of August 2021, which is the same date as the letter. We've just had a look at the index of the first-tier bundle, but I can't.
Wouldn't be
Well,
served.
second, yes, I see.
I can't confirm that the bundle.
Well, I mean, no point's been taken on it.
No.
It doesn't matter. It was just a curiosity, and if we were reproducing bits of these things, one would say, if we were being careful, Annex so and so refers to subject to a document. So, we just quite like to know what the
That's what it
could
is.
not be more than a footnote.
There's a beautiful
like
bundle
footnotes.
for the first tier with all of those annexes. I would need to check in our
Yes,
notes
that's
when it was sent to the appellant. But as your lordship says, it says Annex X. One would think, well, can I have it then, please? If one doesn't have it already.
Yes, but it's pretty clear that from our understanding and practice that bundle was sent with the appeal. Those are
Well, that clearly is the bundle that's then used when there are proceedings. But you're saying that you think it was sent at the time.
Double check, I might be wrong.
Oh, okay. I'm being told we would need to double check that. So that was the
I think
understanding.
it'd be worth
but
double checking. And if this formula is it's none of our business really, but if this procedure is used, you write a letter with the reference lots of annexes, but you don't include the annexes. I think you either do include the annexes or you take out the references. It
Yes.
seems to be an unsatisfactory halfway house. Anyway,
Yes, my lord. Yes, we will check that, and I will pass that back.
I think, as I say, just so we can put the right footnote in the judgment.
Yes.
And just this in response to the point on Chimi, I understood Miss Smythe's point, which was that she had understood, as we had all proceeded, that the Upper Tribunal, sorry if I've mischaracterised it, that the tribunal were banned from looking at Article 8 unless the public law points had been.
I have written down we didn't read Chimi
Yeah,
as
No,
banned.
sorry,
Right,
I
yes.
misheard you. I
Yes.
apologise.
I hadn't, unless I've missed something in Jimmy, I think paragraph 673 is saying something else, and my Lord Justice Edis's point about that, which was, I think, so what? It's certainly, it's saying you don't revisit something. It's not saying you mustn't decide
But the
Article
head note
8.
also, I think, is suggesting an intellectual structure,
Yes, exactly.
which perhaps you can't find exactly set out in the judgment. There's a problem with these head notes, but
Yes. Yes.
Well, it would be very helpful if the court was clear that there is no limitation, implicit limitation.
if it's the right thing to do to deal with Article 8,
Yes.
even if you're going to find a public law flaw, the court
because
should do it. That's
yes,
what the tribunal is doing. Yes,
that
which
is
it may or may not be.
critically important.
Yeah.
Yes, and then the final point was, yes, the final point I won't respond to because it doesn't really arise from the from the submissions on
Well,
the first ground. Thank you.
Thank you both. A great deal of work has obviously gone into preparing for this case, and we are very grateful for those who have done it, grateful for the submissions we've had today. We will be reserving our decision. Judgments will be supplied in draft in the usual way, and only for the purposes restated in the Counsel General for Wales case, and it's important that copies of the judgment are not given to anyone save to the extent necessary for those purposes. Thank you all very much.